So, how has ED investigated multiple cases so far, and has there been multiplicity as far as the various FIRs are concerned or ECIRs are concerned? Your thoughts on the matter?
According to me, ED in the recent past, maybe in the last 5 or 10 years, has grown way beyond what the purpose of ED was. If you go by the Prevention of Money Laundering Act and if you go by the objectives, it was meant to basically try and nab the cross-border movement of money for terrorism, narcotics, etc. And it is only for that purpose this act was brought in. One very disturbing feature of the act is, and unfortunately it has, that part of the act has been upheld, and that is that there is no FIR required to be registered. So you don't know what is the case against you if an ED case is registered against you. The ED simply has to have something on its file and the investigation starts on that basis. That is highly objectionable. That strikes at the very basis of fairness in any investigation, because if there is an FIR, you know exactly what is the allegation against you. The second is that being charged of a predicate offence is also a prerequisite for ED investigation to start. Now, a predicate offence, when the original PMLA was brought in, very few offences were listed as predicate offences. With passage of time, if you see the amendments that have happened to the PMLA in the last 10 years, almost any and every offence under the Indian Penal Code now is a predicate offence, with the result that ED can step in into any FIR. The danger of this kind of amendment is that today what is happening, that even if there is an FIR where there is no money involved or there could not be any money involved, but still ED gets in because that particular offence is listed as one of the predicate offence. ED continues to investigate matters even if the predicate offence is closed, and I have seen large number of cases where the FIR in the predicate offence is found to be without any basis, the charge sheets are not accepted, the case is closed by the jurisdictional magistrate or by the court. ED registers another FIR, the same very FIR, and the ED becomes the complainant itself and continues with the investigation, because technically the predicate offence is still there because of the FIR by the ED. Now this is complete I would say misuse of the authority under the Prevention of Money Laundering Act. I think the purpose for which this act was brought in is completely lost sight of by the Enforcement Directorate, and today ED is now really becoming a tool at the hands of the political executive to target anyone and everyone for political reasons, and that is something which is very disturbing. We have seen cases after cases being registered against people who by and large don't have a criminal history, only because the ED feels that they need to be investigated. And the Supreme Court also, in my view, has delivered a judgment which of course is still pending review, where it has held that even the statement made to the ED while in custody is admissible for the purposes of conviction. So just imagine somebody is picked up by the ED, forcibly made to give a statement, and that statement can be used against him for the purposes of his conviction. Whereas in normal criminal law, a statement made to the police cannot be used in any trial, and that has to be corroborated by independent evidence. Here there is no such requirement. So these are such draconian provisions that I think it's high time that the courts were to re-examine the constitutional validity of the act itself and try and see the purpose for which it was originally enacted, and whether that purpose is being subserved or whether the act is being used completely for something for which it was never enacted in the first place. So I think it's a very I would say draconian piece of legislation, or rather a draconian method of using this law, and so far the courts have not given any relief to the citizenry in this expanding power of the ED going way beyond its remit.